Here are all the topics that are going to be covered within the Supreme Court revision videos. This video is going to focus on judicial activism. What powers does the Supreme Court have, and what is the power of judicial review, and how has it been used? This is what we are going to focus on now. Judicial review is the power of the Supreme Court to declare acts of Congress or actions of the executive unconstitutional, and thereby null and void. The power is not mentioned in the Constitution, and this is where the Supreme Court found the power for itself after the landmark Marbury v. Madison case in 1803. By using its power of judicial review, the court can, in effect, update the meaning of the Constitution, which was written nearly 2 centuries ago. Using its power of judicial review, the Supreme Court has evolved itself into a host of political issues, not least in acting as a guarantor of fundamental civil rights and liberties. It is this that helps give the court its political importance, because many of the issues dealt with by the court are the key political issues of the day. These are political matters that parties disagree over and elections are fought for. The importance of the court was demonstrated in the case of George W. Bush versus Albert Gore Jr. in 2000. 5 weeks after the presidential election on the 11th of December 2000, the Supreme Court ruled that the manual recount scheme devised by the Florida State Supreme Court was unconstitutional because it violated the Equal Protection Clause of the Constitution's 14th Amendment. The 14th Amendment requires states to guarantee equal rights and protection to all citizens. In the same decision, the court also ruled that because of time constraints, it is evident that any recount seeking to meet the 12th of December deadline will be unconstitutional. The court was seen by some to be handing the election to George W. Bush, rather than being seen as using their power of judicial review to declare actions unconstitutional. The power of judicial review not only gives the court political importance, but is also said to turn it into a quasi-legislative body. This is because decisions that the court hands down have almost the same effect of law that are passed by Congress. The Founding Fathers were determined to try and keep the judiciary politically independent and free from political pressure. This means judges could decide cases on their legal merit and with no regard to political favour. That was why federal judges were given life tenure and Congress was prohibited from reducing judicial salaries. However, when the court later made controversial and somewhat political decisions, they faced accusations of judicial activism. Judicial activism is an approach to the judicial decision-making process that holds the judges in their own means. This means that they might make decisions to promote desirable social ends because of what they believe in. This is an approach to judicial decision-making which holds the judges to account. This means judges should use their positions to establish precedents and even make controversial decisions if necessary. The Founding Fathers were at pains to keep the judiciary politically independent. This makes sense, as judges make decisions based on their own merit if they follow judicial activism and do not bow to political pressure. Some examples of judicial activism that you should know are Bush versus Gore in 2000. This led to accusations of political activism by the Supreme Court for obvious reasons, as it gave the presidency to Bush. Roe versus Wade in 1973, another famous case which declared a woman's right to an abortion as a constitutionally protected right. An activist court is said to be one that leads the way in reforming society. You must question, is this seen as a good thing? In the 1950s and 60s, Chief Justice Earl Warren was seen to push for civil rights for African Americans and increased rights for arrested peoples. This was seen as judicial activism. Activist judges are also less likely to bow to the legislative and executive branches of government and see the judicial branch as equal and independent. Should Americans be worried about judicial activism? This is a question that is running through America currently. There is a common argument that judicial activism cannot be justified. Arguments justifying judicial activism include the principles of the Constitution are clear, and it is the role of the court to protect them from dilution or erosion by other branches of government. The court's own decisions are not immune from error and must be reversed if necessary. Legislators are often risk-aware and are slow to act for fear of offending one group or another. Consequently, important social change can only be achieved by the court taking the lead and striking down anarchic legislation. State laws, in particular, are likely to promote values which have long since ceased to be acceptable. Arguments attacking judicial activism include: the Constitution is vague in many places and its provisions subject to interpretation. Consequently, no one can claim a definitive knowledge of its meaning, and as an unelected body, the court should defer to the judgment of other branches. As the court lacks the legitimacy of the elected branches, it should strike down legislation, only if it is in flagrant breach of the Constitution. Judges are not experts in social policy, and if they attempt to substitute their judgment for legislators, it is unlikely to produce successful policy. If justices are seen to use judicial review to advance their own policy preferences, they risk eroding the standing and authority of the court. If the court reverses its own decisions, especially within a relatively short space of time, again there is danger that its authority can be undermined. Federalism is a cornerstone of the US Constitution, and in striking down state laws, the court is denying states the legitimate right to protect regional ways of life. Judicial activism is a term which lacks precise definition and is surrounded by confusion. Arguably, the most objective definition is that the judicial activism is the overriding by the Supreme Court of a state or congressional law, or the reversal of one of the court's own precedents. Thus, when defined, judicial activism can be practiced by both conservative and liberal justices. However, many people believe that judicial activism is an approach to judicial decision-making which holds that judges should use their position to promote desirable social ends. For example, they lead the way in reforming American society. Is judicial activism something negative? It is the job of the court to limit the political branches of government if they step outside their constitutional powers. This means that the judiciary will have to declare laws passed by elected officials unconstitutional, as well as putting a stop to unconstitutional actions taken by the President. The concern is that the courts might appear to be leading the way in public policy making. This is going to be looked at later on in the video. However, judges know that if their decisions stray too far or too long outside the mainstream of public opinion, then they may be forced to moderate their decision or lose their only true method of enforcement, the acceptance of their decisions as legitimate by the populace.